can a lawyer pertain medical records?
Claim medical records.
That's more of a question that I can answer for you, Philip. If the lawyer represents you and you sign what's called a HIPAA form, which stands for some fancy long name of an act, which is shortened to HIPAA, and you've signed that form and given them permission to get your medical records, then yes, they can get them that way. And there's some instances where they can actually issue a subpoena from a pending lawsuit to subpoena your medical records in that form of fashion. But usually most lawyers in Mississippi are obtaining your records through a HIPAA authorization which you signed. If your records are being obtained without your permission, then you do need to probably consult an attorney on that and see if you have some kind of relief you can seek.
And coming right off of his question, it's a little not very similar, but can you answer what happens if I have an attorney who decides he's not going to release my information to me because I've decided, hire another attorney? So your thoughts around
Sure.
that?
Well, a lawyer is obligated to return client files to the client.
Mm-hmm.
The lawyer can keep what's called work product, their own documents that they created, their own notes related to the work they did on the case. One of the things that I encourage people, I get phone calls, I'm sure Johnny does too, mm-hmm. from people that are looking to hire a lawyer and what should I do. And one of the things from being a good client standpoint would be to make copies of your documents and provide the lawyer with a copy. Sometimes as people switch lawyers, if a lawyer's terminated the relationship or the client has, the client can be in a posture where they have a hard time getting their files. If you would keep copies of things as you go and don't turn over originals unless the lawyer needs the original, it can be helpful should there be a transition later.